A subpoena for Karl Rove to testify to the House Judiciary Committee has been forwarded to the Obama administration, meaning in our third story in the countdown that the new president's counsel will have a say as to whether Mr. Rove is cloaked by so-called executive privilege. Vestigial executive privilege in this case. As we mentioned in last night's news hour, the chairman of the House Judiciary Committee, John Conyers, once again having subpoenaed Rove, the former White House senior advisor, to testify on February 2nd, Monday. The primary subject, Mr. Rove's role in the political firings of 9 U.S. attorneys in 2006. Rove had refused to testify, refused even to show up the first time around, claiming executive privilege backed by then-President Bush. Rove's own lawyer, Robert Luskin, has said, quote, "We will do our best to work it out with the new president." And Luskin says he has forwarded the subpoena to the Obama White House, according to TPM.com. Luskin is asking the Obama administration to give an opinion on whether former President Bush retains his ability to assert executive privilege. But Luskin added that if the Obama administration denies a claim of executive privilege for Mr. Rove, a negotiation between Rove, Bush, and the Obama White House would ensue. The issue might then go to court. White House Press Secretary Robert Gibbs said today that the Office of White House Counsel is studying these issues and will offer a recommendation. Let's call in FindLaw.com columnist, author of Worse Than Watergate and Broken Government, John Dean. John, good evening.
Good evening.
The first part here, how do you expect the Obama administration will respond to a sort of plea for help from Karl Rove?
I thought it was an interesting ploy by his lawyer to chuck it over to the White House. They really don't have to give him anything, but it sounds like they're going to give him something. And I think what they'll do is be very generic. They'll say, yes, indeed, former presidents do have some limited privilege. As far as we know, that privilege really only extends to that president himself. It's never gone to a staff person. In fact, Bill Clinton's aides testified after he left office. So I think it'll be rather generic and not a lot of help for Rove. That they're going to make them make their own decision what they're going to do.
And what would his next step be? Where could he take that limited piece of information and use it possibly to his own advantage?
Well, I think what Bush will have to do is make a call. Is he indeed going to say, yes, I'm going to try to prevent people from getting into my administration through my former aides? And if he does, that'll test that privilege. It happens to be in court already. He's lost in court once. He lost at the lower court level. It's in the Court of Appeals right now with Harriet Miers and Josh Bolten. Briefs are due in February 18th, I think it is, and the Obama administration will, of course, be filing the briefs now, and they may give more signals at that time about how to handle this issue.
Well, if either the Obama White House does not issue any position on this, or it issues that very tentative one that you described, and it winds up in a court somewhere, and there's no finding by then, what happens on Monday, and what happens if Rove chooses not to show up before there's any kind of a court material for him to work with?
Well, you know, it's going to come down to the short strokes at some point. And what we've got to hope, Keith, is that the Obama administration departs from the position of Republican presidents who refuse to enforce contempt of Congress during their tenure. And it's always, for decades, it's been the law that if you didn't testify, you would go in front of a grand jury and better have a very damn good reason why you're not going in front of Congress when you're subpoenaed. And I think that's where we've got to get back to that. And this is Obama's chance to indeed get back to the law.
John, you mentioned Josh Bolten, you mentioned Harriet Miers. Could there be a domino effect here, too, as Rove's subpoena goes this time, so do past or future ones on Bolten and Miers?
Well, yes, indeed, the way they handle Rove, and as well, you could say as Bolten and Miers go, so will go Rove. These things happen to all be kind of right coming to a head in a confluence right now. So the issue is going to get sorted out, I'd say, in February, and we'll know. And indeed, I think some people are going to have to appear in front of Congress.
And what is useful, if anything, in this? What do we need to watch in terms of trying to understand the likely response of the Obama White House and counsel and the Department of Justice towards the prospect of further prosecutions and further subpoenas of former Bush administration staffers and even cabinet members?
Well, indeed, if the Obama administration makes it clear that they don't think that the executive privilege extends beyond a former past president in very unique standards with very high unique situations with very high standards, that's going to throw the signal, and that indeed could start a very clear pattern where countless investigations, where Congress wants to find out what happened to try to repair some of the breaks that occurred during the Bush administration and start repairing that broken government that I'm one who certainly have talked at some length about.
Lastly, John, if some court somewhere decides that Mr. Bush does have some retroactive or vestigial rights to claim executive privilege, how far back would this go? Could Mr. Clinton claim, if anything ever came up from his administration, now that he has executive privilege dating to 2000? Could somebody related to FDR make similar claims about the 30s?
This was the issue that came up in the executive order that Obama issued right after coming in office, where former presidents had the right to exert executive privilege over their papers. It really goes back all the way to Truman, who was the first president who tried to use it, and literally picking something out of thin air, he created this privilege, not knowing if it would work or not. He bluffed the House Un-American Activities Committee successfully. So we don't know what will happen in the future with this.
And the attorney for Truman at that time said recently he regrets that like nothing else in his life. John Dean, author of Broken Government and Worse Than Watergate. As always, John, great thanks.
Thank you, Keith.
Yesterday issued a subpoena for Karl Rove in part to find out what happened with Karl Rove, or what was Karl Rove's involvement with politicizing the Justice Department to pursue bogus charges against you to get you out of the way of Democratic politics in Alabama. And I'm curious, do you think that it's possible that this subpoena will be enforced this time?
I think so, and I know I'm going out on a limb here, but I spoke to John Conyers a couple of times during the Democratic National Convention, and I am absolutely convinced that he is 100% committed to seeing this through. And we've had a change of leadership in Washington, and I think in part it's freed up some Democrats. It's given some other Democrats a little more oomph, and I think they're
well, isn't the critical thing though going to be whether Eric Holder at the Justice Department, since they're the ones who will have to force a subpoena, unless Congress decides to do it through the Capitol Police, which is unlikely, that Eric Holder will pursue this?
Well, I believe that yes, I think it is important. I think that if Congress does this, I think that the next Attorney General, and I'm assuming that it will be Eric Holder, that he will also. I don't think he will fight Congress over this issue. I think if Congress takes the lead, then I think this Department of Justice will allow that subpoena to be served and will order Karl to come and testify. You know, one way or the other, Rove is going to be before that committee, and he's going to either have to lie or tell the truth or plead the fifth. And I think that takes us. You notice that Mr. Lund, Rove's attorney, said that he was only following Bush's order and never asserted a personal claim of executive privilege. Well, I wonder what other orders Mr. Rove might claim that he was following if he's brought before ready to testify.
Yeah, this could get very interesting, and it could go all the way to the top, or to the former top. In the minute we have left, we're talking with Governor Don Siegelman, former governor of Alabama, donsiegelman.org, his website. Please get over there, check it out, get on his mailing. What can our listeners do to encourage forward activity in this?
Well, I think the most important thing that I ask your listeners to do is to do what you suggested. That is pick up the phone and call Congress, call John Conyers, and thank you for subpoenaing Karl Rove, but to stay after it until we get to the truth. Right. Call Nancy Pelosi's office. You can thank her for her recent statement that she did not think that the politicizing of the justice should go